Hello, hello. Are we live? Can people hear me? Are we live? Test, 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 test. Ooh, Mike's a little quiet. Mike's a little quiet. How's my audio? Hello, Ada Head. Hello, Brandy Thompson. How are you? We are starting 11 minutes early just to make sure we get all the questions answered. I had a little bit of free time. Brandy, I'm glad to hear you're still fighting your case. Hopefully good things are happening. Hello, Dantana. Hello, Mr. D. Dantana, I saw your post. If you get back to the intake staff, I'm happy to schedule a conversation. I don't want there to be any chance of a misunderstanding. If there's something that I can do to help, I want to. Okay. We have a question here from YouTube user the Head, who says, "How long for a judge's opinion on a motion for summary judgment? I'm not in a hurry. I just don't want to miss a thing." Ada Head, I would say 3 to 18 months is the real answer, depending on the jurisdiction and the judge. 3 to 18 months to get a judge's decision on a motion for summary judgment. Dantana, whoever you were speaking with in intake, just tell them that you spoke with me on YouTube, and I would like them to schedule a call. They will confirm it with me, I'm sure, because people try that. But just tell them you want to get in my calendar. In New York, federal court. Dantana, I should read the question. Dantana Slim says, "What's better, federal or state court in New York?" Federal court, because you can include all of your federal, New York State, and New York City claims in the same court. Victoria, who you were working with, is fantastic. Victoria is the best intake professional I've ever worked with in a variety of ways. Really tremendous. Super, super amazing. Hello, Zinro. Hello, Fortune. Hello, Mr. D. Hello, everyone. One of you, and please don't send me gifts, but one of you sent me a really lovely tequila. So I don't know if they're going to be in the live stream, but I wanted to say thank you for the lovely tequila, and we'll start off the live stream right. Oh, that was really lovely. I'm not a tequila guy. That was nice. Thank you. Thank you very much. Yeah, Dantana, I hear you that she has all your emails. Just let her know you want to have a call with me. We can discuss it. Maybe there's a misunderstanding. I hope you understood my concern that I expressed on that posting, but I don't think it's a good thing to have the conversation in the public eye. I mean, primarily because I don't want defense counsel to find my concerns about the case and that how somehow be used against you or something like that. You know what I mean? I'm trying. I'm definitely not the best. Dantana says, "Perfect, you are the best." I am not the best. I am merely what you get. I'm the only one who's doing the YouTube channel right now. That's not true. Brannigan is, I guess he still makes videos. He did a series of shorts. Brannigan Robertson did a series of shorts recently that like just died on the vine. They went nowhere, and I thought they were pretty good. I thought they were pretty good. I was shocked because sometimes I disagree with some of the videos he makes, and he's good. He's good. I think he makes good videos. I can't say if he's a good attorney or not. I don't know him, but hopefully his videos keep performing well because I think he gets good information out there. Tez Zinro says, "I noticed my local FEPA has extremely low rate of cause findings. Like one office had 2,000 plus complaints and less than 10 for cause findings. Wow. 2,000 plus complaints and less than 10 for cause findings. That's wild. Ted Zinro goes on, what's up with that? Why do some so rarely find cause? I don't know. I mean, listen, I'll say this to Zinro. Like, you could say that same numbers to some extent about our firm in terms of the cases we take, right? Like, there's a lot of people who call us up and are just like, my boss drove a Porsche, so he must be a Nazi. And you're just like, what? That's not a claim. Shut up. Like that. And those cases probably get filed as well. So like maybe that accounts for lots of the not for cause findings. But yeah, I mean, I also listen, 10 out of 2,000 is exceptionally low. So I don't really know what's going on there. That's concerning. Mr. D says, so I have a question. I reluctantly settled with my previous employer, and now they are dragging their feet issuing the paperwork for me to sign because the state agency wants to know the details. Any suggestions? Are you represented by counsel? Your counsel should be able to give the details in like 2 minutes to the employer, to the state agency. Latoya S, they include the original filing because they want to grant the employer the opportunity to respond in full in their position statement to the entirety of the original filing. Fortune asks us, I have a pre-hearing call on 5/16 and my notice of discovery hasn't been answered. The attorney said they won't answer until the 5/16. Should I send a motion to compel? Well, where is your case pending? The answer is gonna change drastically based on where your case is. Like, are you on a discovery schedule? Do you have discovery deadlines? Or are you just doing discovery on your own? Because if you're just doing discovery on your own and there's no like discovery deadlines set by the court or the agency, then they're just going to ignore you until they have deadlines. Paula plugged in says, turn down dumb offer at mediation Wednesday. Only the strong survive. Ugh. Yes. Good luck to everybody fighting cases. I love it. I love the attitude. Fortune goes on. I want them to settle because my discovery requests are pretty damaging for them. Seems like they are willing to go to trial. Why? Uh-oh. What is that? What is going on? Someone's calling me? Someone just called me on my computer. What's happening? Okay. Gotta find the screen. Gotta find the live stream. Okay. Yeah, Fortune, if you want them to be afraid, so they might not even look at your discovery request until there's a deadline. So I hear what you're doing in terms of pushing them into discovery, but if the court has not issued a discovery schedule with deadlines attached, they might not even look at your discovery demands, so it might not register for them yet. Dantana, I'm glad the sound is perfect. The sound engineer I worked with is fantastic. I also appreciate all the help from Viral Shedding Zombie and John Doe. Like a bunch of users of the channel really helped me out. That was amazing. Thank you so much. The discovery deadline is 5/16. I mean, they can turn in their discovery on 5/16 if that's the deadline. Brandy Thompson says, can you explain a state tort claim? What state? Depends on the state. Sometimes I'm allowed, sometimes I'm not. Mr. D says, I'm pro se, which makes me nervous because the attorney wanted me to withdraw the case from the state agency as part of the agreement. Get the agreement in writing first. Like the agreement, you can withdraw from the state agency once you have a signed agreement. TS78 says, do cases with attorneys attached settle faster in mediation? And what is the average time frame for settlement? Yes, I do think cases settle faster at mediation. I think cases are quicker to settle generally when there is representation on the plaintiff side. What is the average time frame for settlement? I would say only about 15% of our cases. I mean, Only 15% of our cases resolve in the first 3 months. But overwhelmingly, I think 80% of our caseload settles between 3 and 9 months. So, Randy, I am not allowed to answer state law questions about North Carolina. I apologize. I can answer federal employee EEOC questions that happen in North Carolina, but I cannot answer state law questions based in North Carolina, even if I know the answer. I'm not allowed. Also, Brandy Thompson, this is a rude question, but did I go to law school with you? Oh, okay. I was like, it's a small world. Nadine asks us, is it uncommon to ask for Cobra subsidies and as compensation in your demand letter? No, very common. Lots of people want Cobra subsidies. There's a ton of people who want their Cobra paid for, and it's a perfectly legitimate ask. I would characterize that as a significant part of the economic damages in many claims. Thank you so much for liking the stream, everybody. The likes are how we get people to know about the stream, so it's very helpful. Apparently, we're running ads right now, so you're not hearing what I'm saying anyways. But yeah, when you like the stream, it helps us to pop up in the algorithm for people, and then people come join the stream and can see and get answers. So thank you very much. I think you're all watching an ad, so that's why there are no questions coming in. But once you have questions, please let me know. Let me know. Let me know. Okay. Questions. Randy Thompson says, as it was told, my federal case was a state tort. I don't believe this is true, as I was never a government state employee. I also asked this as a general question. So, Brandy, I mean, generally speaking, as a layperson in North Carolina, who's not allowed to answer state tort questions in North Carolina, there are claims like hypothetically in New York, if you like had a intentional infliction of emotional distress claim against the federal government, like that would maybe be a state tort. But even then, there's questions about bringing state tort claims against federal employers. Were you a federal employee? I don't. You said you're a federal government employee, so like it's going to depend on what the claim is. If it's workplace discrimination, workplace sexual harassment, those are definitely going to be federal claims, and you might look at bringing additional claims. Right. Well, if you're a federal employee, you work for the federal government, not the state. So it would you would go, if it's workplace discrimination, workplace sexual harassment, you would engage in the federal EEOC process for federal employees. Nadine, I see you retracted your question. I think I already answered it. Hopefully that's okay. Anish, why won't my attorney discuss emotional distress or punitive damages? I don't know. I guess you're probably engaged in settlement talks, and punitive damages are hard to capture in settlement talks. Emotional damages you can capture in part in settlement talks, but they're a little bit more speculative, so it's hard to capture the full value. The easiest form of damages to capture in settlement talks is economic damages, so often attorneys will only concentrate on economic damages. But I do think there should be discussion of emotional damages, and I think you should talk about potential punitive damages being used as leverage in settlement. Mr. D says, last question. If their attorney decides to go back on our agreement after it's withdrawn from the state agency, is this something the state agency will take action on, like reopening the case? Mr. D, if you have an executed settlement agreement, and then, fully executed, all done, all, nicey nice, everybody executed, everybody signed, and then the other side backs out of the settlement agreement after you withdraw your case, you can go to the state agency. You can also potentially go to state court to enforce the contractual agreement that you have, the settlement agreement. Dantana Slim, if you are hypothetically in New York and you miss your time frame to file in federal court, so if you have like a right to sue letter and you only have 9 days to file in federal court, you would generally still be able to look at that New York State 3-year statute of limitations for workplace discrimination, workplace sexual harassment under the New York State human rights law. Luann Marie says, I wish my rights were protected, but New Hampshire justice is a joke. Luann, I saw you post this earlier on one of the videos. So you have the same federal protections that every other state in the country has. I live in New Hampshire, so I can tell you that there's not. You're right to an extent that there's not like a huge built out state apparatus for workplace discrimination, workplace sexual harassment. It's not as built out as some states, but you still have the federal protections. The Te Zinro says, you've mentioned before that it's hard for people with mental illness to find representation. Is it also difficult for people with developmental disabilities, such as Down syndrome and autism, to find representation? I know developmental disabilities are on the EEOC strategic action plan. Does that change anything? I didn't have trouble, but I'm curious if I am an outlier. So I will tell you that I don't even know how to say this without sounding like a bigot. People I've noticed have an overwhelming desire to help individuals with Down syndrome. So when I was like a kid, I worked at a newspaper and I did like some sports reporting on Special Olympics. And obviously people with Down syndrome are just human beings. They're all different, right? But a lot of people perceive folks with Down syndrome, living with Down syndrome, to be super likable and friendly. And there's like this outpouring of love for people who are dealing with Down syndrome. So I don't think people with Down syndrome have any issue obtaining representation. Autism, it's a spectrum, right? There's many different kinds of autism. It's a spectrum. I'm actually having a gentleman, a good friend of mine on the channel. He operates a piano program for individuals living with autism, children, obviously not, I mean, some adults, but mostly children, not trying to infantilize people living with autism. And I'm having him on the channel because I find his program to be so amazing, and it works great for everybody else too. It's not just for people with autism, but it's kind of an amazing program. And I just thought it'd be cool to have him on the channel. He's a great guy. He's been doing this for decades. So I'll have him on. What do we have? Tu Lamort says, so in one of your videos, you talk about how firms will say they are too busy instead of being honest so as not to trigger reactions from emotional people. Obviously, I'm paraphrasing. How do I get the truth so I don't waste my time looking if I don't have a case? Tu Lamort, if you want to give me the details in a question here, I can tell you sounds like a case, sounds like trash. I don't want to be rude. I don't want to call your case trash, but like I can tell you straight up, like I wouldn't take that in a million years if you want. And I don't want to make you angry, but I do want to give you a true answer. Anish says, is a director of a company who lies against you showing malice, lying about their employees? I mean, malice sounds like a legally defined term in some jurisdiction. Like in general, malice, I don't think that's necessarily in play, but I don't know what jurisdiction you're in or what specific laws are defining malice for your purposes. So I can't answer that question. Gabriel's Tears, for Family Medical Leave Act retaliation and termination, can one ask for what the long-term disability benefits would have been? Long-term disability benefits. Are the long-term disability benefits supplied by Social Security or by a program through the employer? Brandy Thompson says, what about federal tort claims? I'm curious on when a claim like this is supposed to be filed. Upon being issued a right to sue letter, you only have a small window to file. Brandy, are you dealing with workplace discrimination and workplace sexual harassment? Like, what are you dealing? Like, can we give voice to what this tort is that you're trying to discuss so I can understand? Zenro says that's really cool. Look forward to seeing that. Oh, you look forward to seeing the piano program for people living with autism. It is super cool. It's it's amazing. That's rude because it's like assuming that people with autism wouldn't somehow be good at the piano. It's I love the results of this program and what it allows certain people who might not have otherwise been able to enjoy creating music to do. Like it's really, really cool. I watched him work on it and perfect it for a decade now, and it's super awesome. SEK 4110. Thank you for saying the audio is great. I note that I did not see you on my calendar, and I was thinking we would have a conversation. If you hit up Victoria and let her know that I'm looking to speak with you directly, I want to make sure that I have that conversation with you in terms of the concerns you mentioned. And it's good to see you. Lisa Loves Soul's Spirit 55 says, I have epilepsy, brain trauma, and no other disorders. This causes cognitive skills decline, so I lost call center jobs because I had to be helped. Short-term memory due to head trauma, so data entry is impossible. I'm really sorry, Lisa. I hope, oh, there's more to the question. So pushed out of job, limited in my hands because of carpal tunnel, and my back is gone. All I was told is to apply for disability, not hiring you, can't do work. So I did because my dog was murdered waiting on a decision. I don't know how we got to your dog, but I hope that since you applied for permanent disability, I hope you qualify. I hope you get the benefits you need. Randy, so workplace discrimination, I would urge you to engage if you're a federal employee with the Federal Employee EEOC process. You do have additional claims that you can bring, but there's not too much reason that I can see why you would just bring the tort claims instead of traveling the defined path for your claims. Generally speaking, the protections built into the defined path will probably be significantly better for you than if you were to bring just federal tort claims. Gabriel's Tier says, program through employer, long-term disability, it would have covered 80% of salary. I would argue that you could seek to recover the long-term disability in your economic damages if it was supplied by the employer. Many attorneys are going to tell you no, I suspect, but I would argue fight for it. I mean, the worst thing about fighting for it and expanding your economic damages more than you might actually be granted is that the other side might not want to negotiate with you anymore, but realistically speaking, most of them will, especially if you have a lot of leverage in your claim. And listen, they might agree with you, they might not, but like better to fight than not, right? The Head says, if the benefits director starts Family Medical Leave Act during summer break before I was to return to work, if the benefits director starts FMLA during summer break before I was to return to work, she said the employer has the right to claw back days. I don't understand the context of your question, Ada. I'm sorry. Anish, is stress, anxiety, or depression a disability? So all three of those can be. Well, anxiety and depression can certainly be a disability. Anxiety and depression can also just be a condition that's not a disability. And I'm not a medical professional, but my understanding is there's anxiety conditions that are like, you have anxiety in this moment. And then there's anxiety-based disabilities that deserve a diagnosis. Stress is stress, right? Stress is the impetus to anxiety, I think. Tu Lamort says, it's too much to fit into these characters. LOL, but I can try. I've learned a lot since beginning this 8 months ago. I passed the EEOC cutoff last week, so I don't think discrimination is possible anymore. So I'm focusing on breach of contract now. Tu Lamort, depending on what state you're in, if you're working for a private company, if you were not a federal employee, you would potentially have state law claims that you could bring, even though you have already passed the federal EEOC statute of limitations. So don't sleep on that. Also, remember, I don't know what EEOC statute of limitations you're using, but many people think it's always 180 days. That is not true. In many, if not most states, it's actually 300 days. So be aware of that. And that is the statute of limitations to be filed in the EOC, not the 90-day statute of limitations that you get from the EOC when you receive a right to sue letter to get filed in federal court. Lisa Loves, I'm really sorry about what you experienced. I don't know that it's necessarily an employment law question, but I'm really sorry. Respectfully truthful, my EEOC case was filed in January. My mediator recently changed the date for the third time. Should I be concerned? I have an attorney. No, don't be concerned. They're just thoughtless. They might be busy, but they might also just be thoughtless. And mediators kind of know everybody wants the case to settle, so they feel like they have a lot of power. Oh, whoa, channel jump real quick. Loss in awareness. How much does a person's image matter in your lawsuit? Like if they have a criminal record and bad work history. So criminal record isn't the end of the world. I mean, it always depends, right? Like if, let me put it this way. If somebody has a criminal record for like getting in a bar fight, that's a problem if part of the defense that you're facing is that they were physically aggressive in the workplace, right? There's also things that are always a problem, like any kind of history of sexual abuse. People don't like domestic violence. Obviously, the whole spectrum of pedophilia is like really hard to represent a person with that in their background, right? That's universally hated. There's a lot of crimes that, can make cases more difficult, but there's a lot that don't. Like if you got like a car theft when you're 17 years old and you're 40 now and you've got a workplace discrimination case, I'm not concerned. I got a lot of intervening years of you being awesome, right? So like, I'm not concerned about that. Let me go back to your question. How much does a person's image matter in your lawsuit? Bad work history is bad. Like if you beat up your boss or you got fraud charges or you were fired for time theft and there was a case filed on the criminal level because it was pretty egregious and like that's in the records, those are all really bad. It's going to be really hard to establish your credibility, right? Now, you also said, what does a person's image matter? Image matters a lot. Like the way you appear, the way you present can be more important because than all this other stuff we're talking about, with the exception of like really bad crimes, right? Like, and also like really bad crimes aren't always so that bad. Like murder, give me the context. You killed a guy. Why'd you do? Oh, he was beating up your sister. Come on, we can deal with that, right? We'll find a way. Do I think it's great you murdered a guy? No. Do I think it's great you defended your sister to the death? I do. And I don't think it's a deal breaker. And I don't think you should then be subject to workplace discrimination because you're afraid that your entire life has been impacted because you fought for your sister, right? Like there's context things here, What do we have? Paula plugged in says, when the EOC starts the investigation process and finds out the company has been sued for the same thing, will it help my case? No. A former employee of the company sued the company and took a settlement. Yeah, Paula, if you can find a company that's never been sued for workplace discrimination or sexual harassment, let me know. That's wild, right? Like, yeah, people be like, I'm suing a Fortune 500 company and I want you to know they've had priors. And I'm like, yeah, about 10,000, maybe 15, right? Like that's not, if you're calling us from any large employer, we've probably had cases against that employer before. It's not as meaningful as you would think. It's routine. Lisa Loves, I totally understand. You're limited. You're not crazy. I would never have thought you're crazy. I just don't know that we're talking about an employment law question, right? Respectfully truthful, you retract your message. I didn't get to answer your question. Please ask again. I want to get you answers. Ahead, they can't shorten your 12 weeks. You get 12 weeks of FMLA. I mean, I don't know. I don't understand the context of what they're doing to you, but FMLA is 12 weeks. It is what it is. Dantana Slim, you retracted your question. I didn't get to answer it. It's not that I didn't want to. I want to. All right, scroll. Whoa, scrolling too fast. Okay. Alfalfa says, "Hi Vince, do you mind talking about depositions? Would you ever encourage a client to go through them for settle?" Yeah. What makes a client a good candidate for depositions? Okay, so every single case. That's not true. We've definitely had cases go to trial where I told people I didn't think they should go to deposition. What makes a person well suited to depositions? I'm not trying to be funny. Do you ever watch Forrest Gump? And he's in the military and he's going through basic training and like he's super fast at putting together the rifle. And the drill sergeant walks up to him. He's like, "Private, why did you put that together so fast?" And Forrest Gump says, "Because you told me to." Perfect opponent. Why did you only answer yes or no? Because you told me to. Why did you stay calm no matter what that guy said to you? Because you told me to. Incredible, right? There's other ways to do it. There's very charming people. There's very expressive people. There's super lovable, likable people. There are people with superpowers in terms of how they come across to other human beings. Those people exist. They are statistically rare, right? The most common method to do great in a deposition is to hear the question, think about the question, go through your attorney's checklist of what your attorney wants you to do, and then answer truthfully. The end. That is the simplest way to do well. If you're a human being with superpowers, communicative, social superpowers of some kind, we can talk about it. Also, if you're a human being who thinks they have social superpowers, statistically speaking, you don't. Right? There's a lot of people who are like, "I am so charming." Just think about every guy who's like, "Got to beat the women off with a stick." Bet you don't. Bet you're full of shit, right? So there are people who have those powers, really. And those people, we might take some risk. We might make a plan. We might do a thing, right? But generally speaking, Alfalfa, the best way is really actively listen to the question. If you don't understand every part of it, or if you forget a part of it, I need the question again. Great. Now think about the question. Good. Long and hard. Give your attorney time if they want to object, depending on the context, right? And then answer. But answer only after going through the checklist of what your attorney asked you to do. That is the most amazing way, the most statistically successful way of going through a deposition and doing well. Respectfully truthful, can I get additional damages for loss of career trajectory? Potentially. Yeah, reputational damages, they exist. Tulamore, I'm sorry to hear about your 300-day statute of limitations passing. I do believe, and I'm not allowed to advise you as to the statute of limitations in Colorado, but it is my layperson's recollection that you may have a slightly elongated statute of limitations under Colorado state law, so you should speak with local counsel about that. You might not be as sunk as you think. You might merely have lost your federal claims. So, worth checking out. Meow Meow says, I got a right to sue letter from California with a 1-year statute of limitations to sue. The employer then avoided terminating me. If the California right to sue expires, can I file EEOC to pursue the same claim if terminated? Your EEOC statute of limitations in California would be 300 days, I believe. So unless new things are happening, so if you're talking about the original, so this is a bit more complex than you present it because you have a right to sue letter from California, which I can't advise you about, but it's tied to events that happen on a certain date. So when your California right to sue letter runs out, likely the 300 days under the federal EEOC statute of limitations would also have run out, I'm presuming, on those events. However, you're going to have at least another termination event, and that termination event could be looked at as retaliatory. So that would be a new claim that you could file under both California and federal law. So you might have still events that would be within your statute of limitations that would be new, but you may have lost some of the value of the old events that would have passed outside your statute of limitations. I hope I did a good job explaining that. It Shouldn't be that complex, but it is. Unbeknownst guy says, what position a plaintiff has if defendant makes... Okay, so you keep asking this question. Let's see if I can understand it, because now we're here together and I can try to get you an answer. What's position a plaintiff has if defendant makes a dispositive motion, but only one of 5 to 6 claims gets tossed? Okay. Are we talking about motion to dismiss? Motion for summary judgment? Which dispositive motion are they making? Okay, so you go on. Is this a form of summary judgment? And what are the conclusions drawn in your perspective? So it's either a motion to dismiss or motion for summary judgment. 2 different standards, 2 different motions. Both can knock certain claims out. If only one of your 5 to 6 claims gets thrown out, it means that only one of your 5 to 6 claims failed to meet the standard presented either by the motion to dismiss or presented by the summary judgment motion. Those are the only conclusions that I can draw. I'm glad we were able to kind of go back and forth on this, because I know you've been asking this question and I wasn't fully understanding it. I understood this better. Thank you very much. Tazinro, I believe the last live stream was posted. If it wasn't, please let me know. I can go find it for you and post it, but it should have been posted. I think it did I'm pretty sure it was posted. I think it did very well. It actually pushed my views for the month quite high. So I think it was posted. Unless they're just saying people are watching it live, which I don't think was true. Lisa Love says, my question is, how do I fight? I was looking for medical help and something stating I'm limited on jobs I can do, not just unemployable. Well, if you applied for permanent disability, you swore you were unemployable, even with an accommodation. So you may still be able to qualify for some jobs. I think there's some ability to work on permanent disability, but you need to speak with a Social Security disability attorney about that. I don't handle disability claims, and I don't handle claims for folks who have certified for permanent disability because they have sworn that they could not have been accommodated, and so I can't really help them. Just different fields. TS78 says, when will my employer be notified of my complaint after the initial intake interview? A couple weeks. Dantana Slim says, if I apply for temporary disability because my health condition is getting worse and I'm unable to work and the accommodation was not given, will this hurt your case? No, temporary disability doesn't hurt your case. It might lower your damages pool, but that's all right. Let's see. KKKYYYMMM. Kim. Okay. I'm always reluctant to read a username that begins with 3 Ks, but it looks like that's just a stretched out way to write Kim. Would fraudulent hiring qualify as constructive discharge? I was promised a managerial position and then found out the role was not considered managerial, but professional, and no bonuses paid. You could look at speaking with a local attorney about promissory estoppel with a claim like that. Like you were promised something and it was they never had any intention of delivering it to you. So there's a breach there. Maybe that's a claim you could look at. Fred Toledo says, great name. I was fired after taking paternity leave. Will a bad performance review impact on the lawsuit? What's the probability of winning? I mean, I can't give you a probability on essentially 2 sentences, but I couldn't give you a probability if I ran the entire case. Like, we're not ethically allowed to give you a probability of success. I can tell you temporal proximity of a termination to a paternity leave is a good thing. Pre-existing bad performance reviews that happen before your paternity leave, not a good thing. Bad performance reviews that happen after you take paternity leave, less impactful, less detrimental to your case. I'm really sorry that you're homeless, Lisa. I'm not going to have the capacity to help you. I can't help people who have certified for permanent disability. I hope that you're receiving permanent disability. I hope you're no longer homeless. There's a lot of Social Security disability firms in the country. I believe they don't charge anything up front. It would make sense for you if you're capable of reaching out to them to do so. I think that would be a tremendous help. They could help you to qualify for benefits if you haven't already. Zinro says, it seems like the EEOC put out something about settling with or suing Walmart at least once a year. Yeah, Walmart faces tens of thousands of claims per year. It's truly. And that's after a lot of attorneys won't take case against Walmart. So Lisa loves Soul Spirit. I agree with you. You do need an attorney. You need a disability attorney. Let's see. Paula plugged in, retracted her message. I would answer it for you if I could. Whoa. Everything jumped ahead. William Highland. William Highland, are you related to my Latin teacher? Says, I have a story stranger than fiction about federal disability retirement, fighting to get it for 3 years. I'm really sorry to hear that. I don't handle federal disability. Bambino Dadon says, hey, Vince, if my company has a policy that says we are supposed to get 2 20-minute breaks every 2 hours paid, we only get 2 10-minute breaks paid for the whole day. Is that considered stolen wages? Well, you're still getting paid the same amount. I think you're just not getting your breaks. I think you can probably enforce, if that is the policy in a collective bargaining agreement, because your union could enforce that. If it's just an internal policy, that may or may not be enforceable. Yeah, meow. I'm certainly happy to answer questions. I don't. Got it. Lisa, I understand fully that you want a one-on-one attorney. That is not going to happen here. Your situation is not something that I would help you with. That is not my area of practice, and I am not currently taking one-on-one clients. I want to be clear with you that I'm not the best attorney to help you, and I want to answer your questions, but it doesn't seem like you have employment law questions. It seems like you have disability questions. I may not be fully understanding you, and I'm sorry if I'm not. I don't want to let you down, but I can tell you that we are absolutely not the firm that will be helping you with this. I would recommend, based on this interaction, that you apply for Social Security permanent disability. If you feel you don't want to do that and you want to work with accommodations, then I would see a doctor, get them to write a letter as to what accommodations you need, and then apply for jobs with that accommodation letter so that you can get the accommodations you need. Let's see. YouTube user Carla. Thank you so much for all the information you provided us. My pleasure. My complaint was just filed. How do I know where it's been filed? My lawyer is in a different county. It's state court. You ask your lawyer. Ask where your case is pending. They should. I mean, they can give you the proof of filing as well. Tiffany, YouTube user Tiffany says, claims served to employer on November 1st, 2023, terminated December 1st, 2023. I'm blacklisted from local industry via employment reference to previous employer, the defendant. How do I overcome this to gain employment? So, one, amend your case to add the retaliation component immediately, because that sounds very clearly like you were the victim of retaliation. Two, did you have friends at the workplace? Do you have people you trust? Get a reference from those individuals, right? If you had a manager or a coworker, somebody you trusted to do right by you, to speak truthfully about how good an employee you were, I would get a reference from that person and list them as your reference going forward. 8 ahead. Have a great day. Anish says, Vince, if there is a write-up that wasn't signed by a manager or employee, can you challenge it? You can, I mean, in the course of your case, you can challenge any write-up. Let's see. Ooh, I think I'm all caught up here. Is that all the questions? Lisa, again, I can't tell if you applied for disability or not, but if you applied for permanent disability, you swore as that application that you could not be accommodated, you could not work. That is what it is. There's no saying, no, I applied, but I didn't swear that. That's not true. You can't You can't apply and not swear that. That's just, if you applied, I don't care why you applied specifically for permanent disability under Social Security, you swore that you couldn't work anymore, even with accommodations. I understand that you may have been doing that for medical care, but that's not meaningful in terms of what you swore, right? Okay. I must not be understanding you, Lisa. I'm sorry. Alfalfa, hi Vince. I've been offered a settlement figure that my attorney likes, but I don't. I spoke with my attorney and the founding partner. Founding partner sounds more neutral. Well, that sounds positive. So, I mean, remember, you're the boss, right? Like, it's good to have. Oh, Alfalfa goes on. Says it's a good offer, but if I'm up for deposed, we can move forward. I want to move to deposed because I want my former employers and workplace attacker to be deposed. Okay. So listen, as long as you understand the risks and you're having frank conversation with your attorneys about the risks and benefits and moving forward, and I think that's positive. I think you're making an informed decision, and at least one of your attorneys does not think you're being foolish. So that sounds positive to me. I don't see a problem with that. Just fully understand the risks you're running, right? Hi, John Doe. I hope all is well. Alfalfa, doing depositions to make an emotional point is foolish 100% of the time. If you're doing it to better your case and to make more money, and you believe that it's worth running the risks to make more money, that's not foolish. I should read your question. Alfalfa goes on to say, am I being too vindictive or too greedy? I don't want to be a bad client, but I'm also not ready to settle without them catching some heat. So Alfalfa, the heat's not going to matter. Only the money matters to the company. Like, there's no like, we went to depots. The real thing they're trying to avoid is having somebody super important be deposed. That's real. I don't know if anyone like that is in play here. And the other thing they're trying to avoid is a big payday. So always look at the payday. That's really where you hit the companies, in my opinion. Lost in Awareness says, how can you make the defense push a case forward if they're just trying to delay it? You can oppose their motions asking for adjournments. We have an attorney here who's famous, who's really well known for not extending professional courtesy. And a lot of firms hate that. But my perspective is like 1 or 2 adjournments, professional courtesy. That's fine. Beyond that, sorry, you got to do your job. You took money, you're billing hourly. What's the problem here? Like, what? No more, right? You're a big law firm. Get your big law attorneys. Like, you got 30 attorneys you can assign to this case. Just make it happen. Anish, what will it seem in the court size if it wasn't signed that you refuse to sign it? I don't understand. John Doe says, things are good, just like the audio in your videos this past week. Love the farm video, and today's upload about staying with an employer with litigation pending was really informative. I'm really glad it was informative. I hope the farm videos are not too out of left field here. I know it's not the purpose of the channel. But the first one I posted did huge numbers. So I don't know what to think about that. Oh, okay. Tez Zinro. I've got a little bit of a story for you. So Tez Zinro's question is, can you think of a particularly wild or weird way you've heard of someone documenting evidence or types of evidence you've had someone come to you with? So a couple different stories. I remember one woman who was being sexually harassed. And listen, I don't want you to take this wrong way, but often it's the women who are being sexually harassed who have the most clever means of catching their tormentors, their attackers, who involved the wife of the bad actor, and the wife of the bad actor hired private investigators, and they together captured evidence of this guy going after the plaintiff, and then used that evidence in both the divorce case and the sexual harassment case. That was great. I also remember there was like a case. I worked on where I want to say the plaintiff at some point like got some chemical on the man's hands, and I guess the man was a slapper, a groper type of character, and he would then put the residue on her body because he was like walking around the workplace like groping her and slapping her butt and stuff like that. So like there was some like forensic thing where she was able to like go and get swabbed, and it's like I think she did it as like part of an assault case, but also obviously a sexual harassment case. The evidence worked for both. There's just really novel, like the limits on what is evidence in these cases and how to prove a case are the limits imposed by the human imagination. Truly. May HM says, can an employer get out of liability if the manager was not following their policies while on the job? No. The employer has liability for what the manager does. Anish, if it doesn't, so if you refuse to sign a write-up, it can be an issue of insubordination. Beyond that, it's not particularly meaningful. Anish. May HM, no. So the employer is responsible for what the manager does, whether the manager listens to their policies or not. John Doe KCK says, would somebody emailing the CEO of a megacorp they work at regarding issues of harassment, etc., possibly trigger them being deposed? Excuse me, timing would matter and the CEO's involvement would matter. Just emailing the CEO would not necessarily trigger a deposition, and I can't say that would necessarily be sufficient for a deposition. Study mode says, once my attorney says okay to an amount, then they begin to draft the settlement. But if the non-financial stuff is not agreeable, then can we adjust that number, or can we only refuse and start depositions? Study mode, you can engage in any settlement tactic you want. So your attorney might be reluctant to start changing the number. So I'll kind of dig into this a little bit further. A lot of times you'll like generally have terms, right? You'll have a term sheet at a mediation, very common. Be the value, some loose stuff like, oh, we have confidentiality, non-disparagement, a neutral reference, you got maybe 10, 12 terms, whatever it is. And then the client will come to the actual written settlement agreement and say like, well, hold on. Sure, non-disparagement's listed on the term sheet, but this goes on for 20 years or whatever it is. And they're like, I didn't agree to that. Well, you agreed to non-disparagement in the term sheet without a time limit. So like, what are we talking about here, right? It's easy for a plaintiff to make up issues with a settlement agreement. The likelihood the other side is, or even your own attorney, is going to see that as a meaningful issue is relatively minor. Like it might not, you might find a lot of pushback from both sides when you engage in that. So staying with that example, right? You agree to non-disparagement in the term sheet. You have a dollar figure in mind. The written settlement agreement comes. It's the non-disparagement term is longer than you expected. And you go to your attorney like, we got to push back on this. I got to get more money. Attorney's like, no. What are you talking about? That's what we agreed to in the term sheet. That was my understanding. That was your understanding. Why are you trying to change the terms now? Then your attorney might go on to say, the other side will stop negotiating with us because they're going to think you're not negotiating in good faith because there was no time limit in the term sheet on the non-disparagement provision, right? So why are you suddenly trying to set one now? They're going to stop negotiating with us and we're just going to end up going to trial. That's a reality in terms of a risk that can happen. I'm not saying it will happen, but it's a risk. Tiffany says, thank you for investing in this channel. Your channel has been the most helpful out there. That's amazing. I'm so glad that you said that, Tiffany. I always feel ridiculous making this channel. So it helps when you say things like that. It makes me feel great. It makes me feel like I'm doing something worthwhile. Thank you. Lost in Awareness says, work is just high school for adults. LOL. There's always something sexual going on between employees and or bosses. Accurate. Although I don't think in my firm. Study mode says, is it rude to ask for a copy of my attorney's draft term sheet so I can anticipate what they will put in a settlement. No, not rude at all. That person works for you. That attorney is your minion, right? It's also your life in their hands, so they should be thrilled to give you the documentation. Thank you, May HM. That's very kind of you. Anish says, I guess what I'm trying to say is if I didn't get my write-ups until my termination and my human resources director only said, okay, so that's a different statement. Anish says, if I did not get my write-ups until my termination and my human resources director only said I can get it if I signed it, is that illegal? Oh. No, I mean, it's not illegal. There's no special laws about how you might have a collective bargaining agreement that says otherwise if you're in a union, but otherwise it's just an internal policy in the company. They can give you write-ups or not. Study mode says, if bad small employer has the same attorney for both civil and workers' comp, and the workers' comp evidence is proving plaintiff is telling truth, is it ethical for that attorney to rush settlement of the civil case before the workers' comp case? Well, that attorney works for your employer. So their ethical duty is to the employer. If they see a way to save the employer some liability because of something they know for the workers' comp case, they should. Not only is it ethical, but they should act on it to the benefit of their client. Oh, Tiffany, your firm also represents my claims. Pleasure working with the team individually. Also, you guys set the bar. Thank you, Tiffany. Tiffany, who are you working with? Which team are you with? I would love to know. Just first names. Just first names. Don't give last names of attorneys. But what attorneys are you working with? Is it a? I think we might be all caught up on questions here, people. This is going to be a short one. That is a good team. That is a good team. John Doe, why are you laughing? What are you laughing at, John Doe? Nadine says, can current employees, former coworkers who can validate claims be deposed if they do not want to participate in the suit? Yeah, you can subpoena them as long as you have the ability to subject them to a subpoena. You can get them in. Diesel says, hey, Vince, can you keep streaming? I won't be able to hop on for a little bit, but I have some questions to ask. Yes. So my intent was to go to 6 p.m. Eastern time, but we're a little late on questions. But I'll try to keep going for you, Diesel. I'll do my best. Big Z says, hey, Vince, how difficult would you say it is to win a constructive termination case? Slightly more difficult than to win a termination case. I'm glad John Doe would also vouch for Samantha. That makes me happy. May HM says, if the manager who discriminated no longer is employed by the original employer, but is found to be continuing their discriminatory practices at the new business for which they work, would that help? Yes. If you can get evidence that the employer has, that the manager in question, the bad actor, has continued with the behaviors you're accusing them of, I think that would be useful evidence for your case as well. Anish, they can say whatever they want, the reason for termination, but if they give multiple reasons for termination, I think you're going to have an argument to attack their credibility on that at the very least. N64 Glenn Plant says, hey, Vince, well, first off, the N64, I assume you're referencing the Nintendo 64. Tremendous. My childhood. Says, hey, Vince, hope you're well. Can we have a daily chicken update, please? Yes. So the chickens are laying well. Our primary coop is producing eggs for multiple households and the local food pantry. So that's very well. Our baby egg layers, which are going to be deployed to that new chicken coop, the natural wood chicken coop that I posted a short of, they're growing up. I was going to do a short of them for their first night staying out because we're transitioning them from the brooder to their new coop. As soon as the weather is going to stop dipping below 50 degrees at night, I don't want them to, you got to kind of ease them into the cold at night. Chickens are very hardy. They have their adult feathers, but I don't want to shock them with the cold. And the meat birds, the Freedom Rangers, are about ready to get shifted out into the chicken tractor to start moving around and fertilizing the garden. So I'm very excited about that. That is your daily chicken update, N64 Glen Plant. And oh, I should mention our 30 turkeys will be moving in very soon to take up residence in our turkey enclosure. We will be producing 30 turkeys for sale this year to go and sit on your lovely Thanksgiving table. They will be antibiotic, pesticide, growth hormone free turkeys raised in a regenerative small scale operation. So, bizarrely, do you know how much people charge for a turkey like that? Like, I'm not comfortable charging. Our neighbor is charging $140 per turkey. Like, it's wild. Like, I can't even, like, insane. I mean, great guy, great farmer. Love the guy. Fantastic. Helped us do our pigs, but like $140 a turkey? Are you out of your? He gets it. He sells out every year. Wild. Okay. I digress. Tech 5280 says, is it common for defense attorneys to delay either a settlement or litigation just to bill hours? Some, yeah. Some of them definitely do it. I have videos on the channel about it. Not all of them. Some of them are very ethical, not all, but some of them, do that stuff. Study mode says, can you knock out the defendant's insurance by blaming the employer for liability? Tips on how to manage the fine line. So I don't think you may not actually want to knock out their insurance because the insurance is an additional pocket of money to pull from. It can create some drama and some complexities because the insurance company will fight with the employer about who's paying what. But, sometimes navigating that complexity is valuable because you have more pockets to pay from. And so you get more money in total. Heart Chakra Medium says, these are great questions. Thank you, Vince, for providing a Q&A. My pleasure. Actually, I'm coming to love the Q&As. They're a lot. They're a lot, but, Anish, is my boss asking to sleep with me? Harassment. That is sexual harassment. That is absolutely a claim, Anish. You should absolutely pursue that. John Doe says a 24/7 live stream of the chickens would be cool. I mean, we could do that. If you actually think people are into that, we could absolutely do that. Ted Zinro says Chimkins and has a little chicken emoji. Are you saving some of the eggshells to give back to them later? We absolutely are. We give them. They actually. So we have kind of a deal going with the food pantry where they give us spoiled food they can't give out any longer. And a lot of that we feed to the chickens. Some of it we feed the pigs when we have pigs. We also, of course, all the chicken shells go into our compost and our chickens work our compost aggressively. So they get them, certainly. John Doe KCK. So we have different groups of chickens. Our egg layers are completely free range and they roam. We lose about one chicken every other month, which is incredible because we have a lot of giant owls. We have a significant hawk population. We have coyotes. Actually, two different kinds of coyotes. We have the southwestern coyote, which is invasive here. And we have the northeastern coyote, which is actually huge. It's like 3/4 the size of a wolf. We have invasive species like fisher cats. We have weasels. We have minks. All kinds of predator pressure. And a ton of them. Like we have motion activated lights on the farm, solar lights. And over the course of the night, if you're sitting out watching the world go by, like animals are going to be activating those lights nonstop. So there's a lot of predator pressure here, but the chickens are very smart. They put themselves away at night. The minute twilight comes along, they're up in the coop. The doors are automated. They close. The coops are very sturdy. We had an issue. We have beautiful red fox. We have a big family of red foxes here, like 8 red foxes. And one of them was just investigating the coop from every angle the other night. And, we're texting back and forth, like, do we need to do something about this? And we're like, well, we built a really good coop, but the farm manager built a really good coop, not me. We just got to trust in the coop, and it worked out all right. The chickens are very smart about airborne predators. They tend to hide under, there's a lot of cover for them to get under, and they watch and they warn each other. It's interesting to watch. Ki says, do you know if you can file a lawsuit by yourself against an employer? Yeah, that's called pro se. You can file pro se. We have videos on the channel how to file pro se. We have some walkthroughs on how to file pro se with certain state agencies, and we have videos for pro se litigants who are representing themselves in court as well. Avail yourself of those. It is a very difficult thing to do, but I hope for good things for you. To Lamort says, if I know for a fact that my termination reason was a lie, and I know for a fact that my replacement is male and paid more than I was, and I also brought up to my employer that my gender was the reason for the 3 complaints I got, knowing the fact that my replacement isn't being reprimanded for stupid crap like I was, could it be possible to prove discrimination? Sure. There's more to it than this. There always is. Yeah. That sounds like a viable claim to me as you're describing it. I would say that that is a claim that would absolutely make it past our call center, and I suspect it would make it past our intake layer of filter as well. It would probably get a call with an attorney. That sounds like a viable claim. Anish, Anish asks, when are hearsay statements admissible in court? I'm not going to list it. I don't want to be rude, but if you want the exceptions to hearsay, I would recommend going to law school. It's probably beyond what I can really share with a pro se litigant. I'll be frank, a lot of litigation attorneys don't know all the exceptions to hearsay. It's something people very near and dear to me rage about because I know someone whose job is to train and supervise attorneys specifically. And how often attorneys will miss hearsay exemptions or objections. Like it's super frustrating, Anish. But your question goes on. What if the manager lies about a statement? Can't hearsay be admissible to them for the plaintiff? You can make an argument for admissions against interest. There might be others that apply there as well. Tulamort says, oh, yeah, I answered that. Excuse me. Big Z says, hey, Vince, my employer moved me from my work site after I complained about sexual harassment from my female supervisor. Do you think this could be a valid case of retaliation? I had no write-ups. Well, a couple of questions. Does the new work, so they moved you from the work site. Did they assign you to a new work site? Are you earning the same amount of money? Do you have the same hours? Are the conditions the same? Is like the new work site terrible because there's no restrooms or no lunchroom or no cover from sun, right? So it's all about the conditions. Normally speaking, the bad actor should be the one who gets moved. But if you're moved and nothing is worse in terms of the conditions or the compensation for your employment or the career trajectory that you had, it may not necessarily be retaliation because it might not rise to the level of a negative workplace consequence. Now, if there is a negative workplace consequence and you're being moved because you complain, that is retaliation. No question. Okay, what do we have? May HM says, if a manager moved from a country infamous for inequality of certain genders as an adult, would this ever help to serve as an argument for the plaintiff? That's a little dicey. That's a little dicey because, like, we'll make up a fake nation, right? Let's say you got somebody who immigrated to the U.S. from the land of Honolulu. Used to be neighbors with Puff the Magic Dragon. And you go into court and you make the argument like, hey, that guy is from the land of Honolulu. And as we all know, the people from the land of Honolulu are motherfuckers to women. You've just engaged in national origin discrimination. I understand what you're trying to do there, and I'm not faulting you for what you're trying to do. I get it. But look at it from the other perspective there. Like, we're dealing with individuals, not with assumptions, right? Now, if you're playing dirty pool as you litigate, and if there's a common belief that men from the land of Honolulu discriminate on the basis of, let's say, gender, would you indirectly hint around that and reference that? Sure. Yeah, of course. We're not here to be gentle women and gentle men. We're here to win a case, right? So if you can do it in a way that is effective without being bigoted, you would, right? And if the land of Honolulu gets mad at you, you'll send them an apology letter. But let's get you the money first, right? What do we have here? Smokey, can you amend a pro se civil lawsuit? Yes. In fact, pro se complaints are probably the most amended document on the federal docket of all time. Because no shade at pro se litigants, but they often don't know how to properly file their motions, so they need to go through many revisions of their complaint or their motion practice, amending repeatedly. Heart Chakra Medium says you flow through them. I'm trying my best. Tulamort says, and what if one of the people who works at the company sexually assaulted me 17 years ago? Does that matter? Yeah, if that person did bad things to you, or if they sexually assaulted you in the course of employment, yeah, I mean, listen, that's not going to be within the range of the statute of limitations if that happened in the workplace. But I could see how that could be a data point in your case, a piece of evidence. Kai says, can you be pro se for lawsuit against your attorney? You sure can. You can be pro se for really any lawsuit. There is very rare instances, like if you're a company, if you own a company, you might not be allowed to be pro se in certain jurisdictions for certain kinds of cases. But generally speaking, you can be pro se for almost any litigation, KI or KL. I can't tell which. Global Family says yes to the poultry cam. So more and more, I think I'm going to launch a farm channel here. My farm manager is ex-special forces. Like, he's quite a character. I've been saying for quite some time now that I think like we should get him on the channel. Not this channel. He's not an employment attorney, but like I think he's a star waiting to be found, right? So yeah, I do want to do like a farm channel. I'm going to call it Fake It Till You Farm It. May HM says, by the way, the sound is great today. No background noise at all. Thank you. We got the sound engineer. We did the we got the screen share, and he was able to really help us out. Really wonderful guy. Incidentally, I've been friends with that guy since first grade. One hell of a guy. His family is amazing. What Nadine says, outside of money, what are the common things that can be included in settlements? So the most common are references, medical benefits. I mean, I always share this story. Like I settled a case for a blind cat once. It's anything under the sun. You can ask for anything you want that can legally be done. And the limitations on what you can demand in settlement are, to a very limited extent, like the Constitution, maybe some state laws. Very rare that those apply. Like, obviously, you can't be like, be my slave, right? Because slavery is illegal for very good reasons, right? So you can't ask for illegal things. You can't be like, I need this guy's head on a platter. Well, murder is illegal. You can't do that, right? Think of it this way. The limitations on what you can ask a genie for in Arabian Nights are very similar to the limitations of what you can ask for in settlement. Like, if you look at it, you're like, well, that doesn't make any sense. You definitely can't do that. Probably you can't. Otherwise, you can. Smokey says, can you file a suit if the manager let your neighbors call your job, making false accusations, then spread the rumors? I mean, you could probably file a claim against your neighbors. I mean, maybe you could file a claim against your manager, but the claim sounds better brought against your neighbors. Maybe a defamation or libel, slander. Look into what a local counsel can tell you about that. May HM says, how can one value the damage done to an employee's reputation? You can try to put a number on it yourself. More realistically, if it is significant, you would hire an expert witness with subject matter expertise in the industry and some ability to quantify reputational damage. There are economic experts who deal in that trade, and you would use one to substantiate your damages, and the other side would use one to say you're wrong. Tez Zinro says, what's the best way to research an attorney, either one for yourself or to get intel on the opposition? Tez Zinro, I have a playlist called Evaluating Employment Attorneys. That can be applied for plaintiff side. It can also, to another extent, be applied to defense side. A lot of the concepts in there are going to work for defense side attorneys as well. Alfalfa says, how common is it for plaintiff's former colleagues who are past or current employees of the defendant to validate plaintiff's claims? How do you overcome this hurdle? A lot of times I try to get affidavits early while people are feeling brave. If you have to, well, also great tactic to do is go to your witness and say, hey, I'm going to subpoena you to make it look like you're being forced to come in here, even though you're not. But I want to make it look like you're being forced so your employer doesn't come after you. You can also just subpoena people and force them to come in and do it the hard way if you have to. SEK 4110 says, in a discrimination case, and the person involved in the organization that you work for refused to be interviewed by the EEOC. So the EEOC technically has subpoena power, but it generally chooses not to use it. And where it chooses not to use subpoena power, those individuals could decline to go in. Now, their employer could still force them to go in, but theoretically, if the employer doesn't force them, they could just not go in. And then it's up to the EEOC to try to use their power. John Doe is absolutely correct about hearsay exemptions. Thank you for chiming in. Ooh, my channel jumped ahead. Channel jumped ahead very far. Okay. Oh, turkey live stream. Yo, turkeys are super friendly. Like chickens are friendly. Like chickens became my friends over time. But when we had our last round of baby turkeys, they would just follow me around, just doing yard work, garden, everything. They would just be like, hey, bro, can we hang with you? And it was like they thought I was their parent, essentially, right? It was amazing. Thank you, John Doe, for telling people to smash the like button. That really helps our stream. Wow, 40 people, 40 concurrent. That's pretty good for us. KI says, will this live be posted to rewatch? It will. I believe it will. Dantana Slims, after applying for accommodation. Yo. Oh. Okay. Dantana, so we have a broken question. Not broken, broken up. Dantana Slim says, after applying for accommodation, I've applied for 48 positions inside the organization, all of which I was denied. Is it that they have me blocked by HR? Could this be retaliation? Yeah, I think it could be. I think they could say that you're a problem employee because you're asking for accommodations. So they're engaged in disability discrimination and also retaliation. Anish, what if they don't move you after complaining about a manager for sexual harassment and then they terminate you? Sounds like a claim. Certainly sounds like a claim to me, Anish. Puree Doyle says, I've been terminated 3 times already. And then again, April 22nd, the Dispute Center for HR emailed me stating that I was still rehirable after I've been terminated for the 3rd time. That is a wild scenario. That's a lot. John Doe says, Anish, that's when you call all the employment attorneys in your area. I could not agree more. Oh, Pure Doe goes on. Excuse me, I was terminated for being tardy after the threat occurred 2 days in a row in fear of my life, but my coworker has not yet been disciplined. So it depends. I mean, workplace violence issues are going to be different from workplace discrimination, workplace sexual harassment. I always recommend for workplace violence issues to check out the order of protection law in your jurisdiction. You might be able to get a stay away order of protection issued by a criminal court. And that would mean the person who threatened you would be excluded from the work site. It's not going to make your employer happy necessarily, but it might make you feel safer. Viral shit. Whoa. Viral shedding zombie says, Vince, do your meaty chickens know their fate? Yes. So since they were baby chicks who arrived in the farm by the U.S. Postal Service, I like to cuddle them and pet them. And I say to them, oh, my little freedom ranger, you will be so delicious someday. And, they get it. It's a good life. Why did the administrative judge ask the defense attorney to file a motion to summary judgment at the pre-hearing conference? Okay, so That's not good. Let me tell you. If the administrative judge is going out of her way to tell counsel to file a motion for summary judgment against you, it means that she thinks the motion for summary judgment might knock out some or all of your claims. So your claims might not be drafted correctly. There might be some issue with your case. And I think the administrative judge might be looking to be efficient in adjudicating your claims and might think the best way to adjudicate your claims is the motion for summary judgment, which would knock your case out, potentially, or at least knock parts of your case out, simplifying things. But generally, that's not what you want to see. You don't want an administrative judge saying, not always, like, listen, I've definitely had cases that went in where, like, we had, 10 great claims and then an 11th claim that we really stretched on because we wanted to make some law, or we thought this would be a novel way to go about this. And you could have a judge being like, I'm surprised that 11th claim didn't get a motion for summary judgment. Like, certainly when I was practicing, I would have filed that motion. And then you'll look at defense counsel's like, oops, so it's not always a big deal or really bad, but it can be less than ideal. Lost in Awareness says, I know that almost everybody knows everybody in the local legal world. Do you find bias with mediators and judges, whether for you or against you? So I'll say this. I've routinely been accused of receiving the favor of and favors from certain judges, certain arbitrators, and certain mediators. It's my existence is odd. Like, I'm routinely mocked for things like this channel, right? People, like, there's a guy who messages me every night on Snapchat telling me what a piece of shit I am for, like, having this YouTube channel. And then I look like a fucking joke and all these things. Like, he gets drunk at night and just rips into me, right? Which, it's fine. He's not a bad guy. He's just unhappy, right? And there's mediators. Like, the first mediation I did when my firm went solo, my original firm that I started many, many years ago, the mediator flat out said to me, great guy, not what you necessarily want to see at a mediator. He flat out said, he was like, I'm going to get you an office. I was like, what? He's like, thanks for hiring me on this mediation. I'm going to make sure you get an office out of this. And I was like, huh? What? He's like, yeah, your office sucks. I'm going to make sure you get a good office. We're going to get you a good settlement here, which, I mean, wasn't horrific because it was a good case and he looked at the case and he knew the case had value and the other side just had to come to the table, right? So it wasn't like he was like going to turn against them or something, but is it truly appropriate to say that? No, right? I had a woman years ago, this is on public record, go into court. She had settled her case and she didn't like the settlement she had taken. So she had gotten this piece of shit attorney to, like, take over the case. And he told her, say that your attorney said he was going to hit you if you didn't sign the agreement. And so she went into federal court under oath and just told a federal judge, she was like, oh, my attorney said he was going to beat me. And she's like, I don't know, 5 feet tall, sweet old, I mean, not that sweet, old lady, like everything, right? She was like, Mr. White said he was going to beat me to death if I didn't sign the settlement agreement. I'm paraphrasing because I don't want you to be able to Google and find it. And the federal judge just looked at me, said, yeah, none of that happened. Thank you, judge. Because I had to sit in federal court and be like, I made this lady so much money and she also got nothing. She blew up the settlement. She was a liar. It turns out she was a liar, allegedly, and she got nothing on the case, right? Because she's an idiot. Allegedly. So I hear. None of this is stuff that I know because for obvious reasons, my representation ended, right? So I've, over the course of my career, received massive benefits from good relations with judges and arbitrators and mediators. That has been, I'm very well liked, although often viewed, not, I would say, by defense attorneys, but by everyone else in the industry as like a jovial character, right? A Tom Bombadil of sorts, perhaps. Maybe that's being generous. Retaliation Nation says, are cases with forced arbitration less likely to settle than court or jury? What if there is very strong written evidence of both discrimination and retaliation? So I think that the instance of settlement in arbitration has a very high settlement rate. I don't know if it's higher or lower, because I don't take mandatory arbitration cases. I only take voluntary arbitration cases when I sit as an arbitrator. I will tell you that I don't think there's any noticeable difference in the cases that we take when we take mandatory arbitration. When we take a case that has a mandatory arbitration clause in there, I don't notice a notable difference, but I will say we generally still file the EOC because they can't keep us from doing that. And we'll often fight the fight on the forced arbitration clause, potentially filing it in federal court at some point and fighting that out before it gets forced in arbitration. If we, so like I don't notice a difference, but I will say that we do everything we can to fight the forced arbitration. Jim Miller says, great information, as this is typical for your channel. Thank you, Mr. Miller. Those are unfamiliar with Vince and his team. They're just as cordial, knowledgeable, and professional as you might expect after viewing his video. Thank you. Thank you so much. It's very kind of you to say. May HM says, are there pros and cons for the plaintiff if the employer's policy for termination was not fully followed after the protected activity occurred? Are there pros and cons for the plaintiff? Yes. If the employer departed from their policies regarding termination hot on the heels of protected activity, that is good for your retaliation claim. May HM says, I knew a very territorial turkey that snuck up on a 250-pound friend from behind and struck him in the back. That makes sense to me. I've known some roosters that were pretty aggressive. Roosters are oddly aggressive towards women, in my experience. And I've never understood why. I think there's something about, like, maybe women aren't statistically as big as men. I don't know. But I've seen a lot of roosters, like chicken roosters, go after women, like in farmyards in my life. Also, geese, Canadian geese. Yo, I saw a Canadian goose mess up a dog. That dog was being an asshole, but man, it was like I got hit with a baseball bat. Like, full wing whap, and like with bites to fall. Like, whew, that dog was not okay for like weeks. It was fine eventually. That dog learned a lesson, hard lesson. BMM says defense attorney had 60 days to file a motion for summary judgment. Half of this period was granted through a motion by the EEOC administrative judge. However, she didn't file a motion for summary judgment. Can I file a motion for sanction for delaying the process? I don't necessarily see that as viable, I guess is my best answer. Listen, can you file a motion for sanctions? Sure, if you have a meritorious reason. Do I think that is necessarily a meritorious reason? Not really. 60 days in the scheme of things is not that much. May HM says he didn't find it funny. I don't think anyone finds squaring off with the turkey funny. Smokey says, are cost of living adjustments mandatory within a company after you reach top pay at your position? They can be if there's a collective bargaining agreement or a local law. Otherwise, no. Big Z says, follow up to your answer of my other question. I don't remember your other question. I apologize, but I'll do my best here. My pay was reduced from $25 an hour to $21 an hour, and now I have an extra 14 miles to drive to work. I just got rejected for the job, though, for my previous HR concerns. That sounds like retaliation. So I remember now. You were moved to another job site because you were sexually harassed, and they moved you because you complained instead of the person who did the bad thing. Yes, you've now experienced a negative workplace consequence. Your commute is longer. You're earning less money. You're having other bad things happen to you. That is retaliation. Anish, you are welcome. Tazzy BYT says, my case of discrimination happened in another state, but I now live across the country. Should I look for an employment lawyer in the state I lived in or the state where the discrimination happened? I would go with the state where the discrimination happened, realistically speaking. Hi, Diesel. Anish asks us, are workers' comp claims filed in federal court In every jurisdiction I'm aware of, workers' compensation claims are filed in workers' compensation court. It's a special court specifically for that. Diesel says, I have a question about constructive dismissal. What meets the threshold? The law makes no sense. So Diesel, we do have videos on constructive termination, constructive dismissal. Have you watched those videos? And if you did, can we touch upon where you feel I fell short? Because I want to, I'll film additional videos to try to build that out. If a plaintiff's personal relationship is irrevocably damaged as a result of the financial and emotional damages, and the split costs thousands, are there any helpful recovery tips, if any? Sounds like you're describing a divorce, so I'm sorry to hear that. You know, I think this, we're gonna go ahead and file this one under, you're asking Vince a question that Vince is not well suited to answer. In terms of interpersonal relationships, I fall desperately short of adequacy. So, I don't think I'm the best person to answer this question. I don't think I'm qualified. Sorry, May. Diesel, what are some real world examples of constructive dismissal? Okay. So if you're working, let's say you're working in Rochester, New York, and you report sexual harassment in your workplace, and your company says, not a problem, we're going to move you to Long Island. Well, that's like 9.5 hours away. I assume you're not going to make a 9.5 hour commute every day. So they're functionally forcing you to move, right? So that's constructive dismissal. They didn't terminate you technically, but they terminated you, right? You're not going to sell your house in Rochester, buy an incredibly expensive home in Long Island, and move across the state 9 hours away to work the same job, probably, right? So that's an example. I mean, another example would be like if you're, let's say you're a rising star in marketing, and you something happens, and the company's like, not to worry, we're going to move you out of marketing, so there's no more trouble. You work in HR now. Well, you're not trained for HR. You're not educated in HR. You're not a rising star in HR. That's that's not your career trajectory. So that's constructive dismissal, right? Get 'em Big Red, YouTube user Get 'em Big Red says, if I have a case number for an EOC case and they said I would, and they said they would contact me if I need more info, does that mean I basically have a right to sue, or are they still investigating? You have a right to sue when you receive a right to sue. So the right to sue is a specific letter. You receive it. And when you receive the right to sue, the day you receive it, your 90 days statute of limitations to get filed in federal court begins. BMM says, my attorney was so happy when the administrative judge asked the defense lawyer to file a motion for summary judgment. She didn't even argue. I don't think I'm understanding what's going on. I don't understand why your attorney would be happy that the other side was being forced to file a motion for summary judgment. Yeah, I don't understand why your attorney would be happy there. I don't think I understand the context of what's going on for you, BMM. John Doe KCK says, aren't the odds of constructive discharge claims succeeding like 1 in 50? Depends on the facts. Always depends on the facts. Yes. Good advice from John Doe to get 'em Big Red. Scott Niebarger says, I love this channel. This channel loves you, Scott. BMM says, can you ask the EOC to assign your case to a different administrative judge? I feel he's biased. You can. I mean, you better have a damn good reason for that opinion that the judge is biased, but you can. Feeding hens is a wonderful time, Scott, especially if you're feeding them something they really like. They become your best friend. That's a great advice. So Ted Zinro says, hot tip for roosters, throw a handful of blueberries in the opposite direction to distract them. My hot tip for roosters is to smack the shit out of them until they know their place. It's not DV if it's a different species. Yes. N64 Glenn Plant. Have you decided on a final spot on the wall for your YouTube award yet? Yes. You can see it sitting here. And I think it's going to go right here. Charles Lara says, what do you do if the people who are supposed to do an investigation don't? You discuss if you want to go into litigation or settle. Retaliation Nation. What a username. Super helpful. Thank you. You are welcome. I'm glad it's helpful. Thank you for saying that. We filed with the state agency in Massachusetts as a first step in keeping an eye on those arbitration bills in Congress. You are on top of things. Well done. I have to drive through Massachusetts every time I go to New York now when I don't fly. And I'm going to be honest. I'm taking issue with the entire area of Northampton. Not ideal. Not ideal for driving through. Interstate slows down to 40 miles per hour. There's like no rest stops. Like, what are you doing? I know it's not your fault unless you're running the DOT in Massachusetts, in which case we need to have a conversation. Okay, BMM. I don't think I understand the context. I don't understand why your attorney would be happy to face a motion for summary judgment. I mean, unless, yeah, why would your attorney be glad that the judge is asking the other side to file a motion that could kill some or all of your claims? I don't think I understand what's going on there. Lost in awareness. What if I accumulated enough points to be fired, but I was kept on for months because I'm the fastest worker, but then I was terminated when I reported a boss? They said my termination was for the points. So this is an argument we have a lot, because a lot of times you'll get sexual harassment or workplace discrimination claims where the bad actor targets someone who's exposed. So like you create a situation where you accumulated points and you were exposed. So it's very common for the kind of guy who sexually harasses people to be like, excuse me, and I don't know anything about you, lost in awareness. I'm just giving an example unrelated to you. That manager might be like, well, I know I'm gross. I'm a piece of shit, but that woman might need her job and she's exposed because she's got a lot of points. So she might be afraid for her job. She might need her job to feed her family. She might need her job to stay, in a home. So she doesn't become homeless. So why don't I go ahead and sexually harass her? And she'll probably have to take me up on it because she's going to be afraid that she's going to get terminated for points. And she'll think maybe I'll protect her if she does what I want. So that's really common. So we end up making argument in the mentality of these sexual harassers, right? The kind of guys who need to use the power disparity to get the sexual gratification they want out of life. So it's very common for us to have to make the argument that like, hey, you didn't terminate this person when the bad thing happened. And you waited until they engaged in protected activity, which would be in this hypothetical complaining of that sexual harassment. And only then did you apply the points to terminate the person. So you didn't follow your own policies. You must not have thought those things were so bad. You could have fired that person for 8 months, but you waited until they engaged in protected activity. So this is retaliation. It's not a retaliation in the course of due business. And that's a pretty strong argument. We've had a lot of success with that. Bubblegum says, is it illegal for a company to have one person doing a job? It's actually meant for 2 or 3 people, but only being paid one salary for it. That is the American way, Bubblegum. I'm sorry, that's not illegal necessarily. Angela Law, I'm not trying to skip you. Can you ask your question again? My ability to go back in the chat to find questions is very low, Angela, but if you ask your question again, I don't want to skip you. I have no desire to skip you. Charles Lara says, is 7.5 years too long to wait for a no merit finding from a state labor commission? Yes, that is too long. That merit commission should be soundly disciplined. Puree Doyle, if I have a right to sue letter and also all the evidence and documentation from damages, how do I file? What is my first step? Do I attach my evidence to the process and what I'm asking for? Okay. So I'm going to assume Puree Doyle for the purposes of this question that you're dealing with a right to sue letter issued by the Equal Employment Opportunity Commission, which is a federal right to sue letter. We have a video on the channel for pro se litigants. Your first stop, though, quick answer should be the pro se support office in the federal court that you intend to file in. Okay, Diesel says, I saw one video you had about mediation. How does bracketing work? That's a great question. Do I not have a video on the channel about bracketing? Okay, I'm going to jot that down, Diesel. I'll make you a long form video. Diesel, can you give me a longer form question with hypotheticals that you post somewhere on a video so that I can go ahead and make you a fully featured bracketing video? I'll probably put 10, 20 minutes into it. That's an important topic. Get 'em, Big Red says a different employee filed a lawsuit for discrimination, and the time was up for his claim as in 90 days. But I filed one almost 4 months later. Is it possible I can use some of that same evidence? Yes. Just because, so first off, that other employee only lost their federal claims. They may still have potentially state and local law claims. So hopefully they're investigating that with local counsel. But in terms of you using their evidence, the fact that they blew their case up, they may or may not, but the fact that they may have has nothing to do with you. The evidence is still the evidence, even if their claims are not viable. Nadine says, is it a good idea to file unemployment while waiting for the case to be litigated? Yes. Gives you money to live on, and it does reduce your damages, but that's money you're not going to pay your attorney a percentage on. So yes. Bubblegum, I was happy to answer your question. I hope it was helpful. Angela Law, ask your question again. Oh, you did. Amazing. All right. Angela Law says, we were wrapping up depositions when the defense decided to call a coworker that was also retaliated against and who has filed in federal court. Why would they do this? Because it seems like self-sabotage. Well, I don't know what they're hoping to get from that person, but they may have been using your case to get an additional crack at depositions on her case. They may think that she is a shit witness. They may think they can mess with her and make her do something aggressive or wild in the deposition. Keep an eye on if they bring in a camera crew to record her deposition. That's a really good sign they're going to mess with her and try to get her to act the fool in the deposition. So there's a variety of reasons, and it could have nothing to do with you. And it's just that they like, well, we got another case over here that we can bring a deposition in because we forgot to ask some stuff in her case. There's a lot of reasons, right? All right, let me go back. BMM says, my attorney was happy because the defense attorney didn't file a motion for summary judgment, and then the administrative judge asked her to do it during the pre-hearing. My attorney said it's because we can educate the administrative judge about the case. That is a bold strategy, BMM. I don't know that I've ever been happy to have to oppose a motion for summary judgment. One, it's a huge endeavor. Maybe is your attorney being paid hourly? Your attorney may be compensated hourly if they're happy about that. I don't know. So it's a huge, 50, 60, 80, 100 attorney hours can go into a summary judgment motion to even opposing a summary judgment. It can be a very sizable endeavor, but also it exposes your case to risk. If there was going to be no summary judgment motion, that's better than having a summary judgment motion, because if there's no summary judgment motion, then all of the claims will be making it to the hearing. Additionally, it's not great that the administrative judge is like, no, we need the summary judgment motion here, because that means the administrative judge has some kind of opinion about your case, that has some kind of belief that there may be some claims that don't make it to hearing, or at least that the process of fighting back and forth over whether or not these claims should make it to hearing has value, which means that some of these claims are at least imperiled in the eyes of this judge. Cassandra 8409, what's the Office of Inspector General do during an investigation? Short answer, not much. It depends. Like, in what context, who's investigating, what's going on, what kind of claim are we talking about? Let's get a little specific, and I can give you a better answer. Get him, Big Red says, I love you, bro. I love you too, bro. Hope all is well. BMM says, sorry for confusion. The chat has limitation. I couldn't give you the background about the AJ and the second motion for summary judgment opportunity. If I continue my comments in your recent video, would you respond? BMM, I will absolutely attempt to respond. John Doe KCK, attorneys that underpromise and overdeliver are better than those that sell you the moon, right? I fully believe that. I think I've shared on the channel before. I maybe even shared with you. A long time ago, I worked for a guy. He's passed away now. He wasn't a monster, but he used to allegedly leap on, he was an older fella, but he used to leap on the table and be like, I'll win you millions. And then he'd just like walk out of the room. And I'd be there with this person who I was now going to have to represent, knowing full well that case was worth like 60 grand or whatever it was, right? Like, it's just not all cases are worth millions. And obviously I was like a baby attorney, and he's like a famous talking head on cable news. And you know, you try to tell the client like, hey, I know that guy said millions, but like, he's full of shit. And they're like, oh no, that's the guy I hired. You're full of shit. And then it's so difficult, right? Like, it's this massive issue. And then you have clients going to trial on cases that shouldn't go to trial. It's horrific. John Doe KCK says, somebody that works for the same employer I could be suing the hell out of contacted me saying they experienced similar issues. Would it be a good idea to ask them to contact my attorneys? So listen, it's always better to find local counsel. If they don't like local counsel and your attorneys, I think you should absolutely do that. But like I always say local, and then make sure you're coordinating. Your attorneys can speak to their attorneys and collaborate either way, right? The thing your attorney should be doing is always being thrilled to collaborate with other cases that can corroborate your case. Okay, we have 25 minutes to go. 25 minutes to go. And then I have a comedy show to attend and a dinner to cook. Let me drink my electrolyte drink. Stay hydrated. Going on an hour and 45 minutes here. John Doe, yes. So John Doe says, to clarify, I'm saying they should contact my attorneys because, well, witnesses, absolutely. Absolutely. Be More Shelley 1 says, hey, Mr. White, I'm in Maryland and the EOC level. I can't find an attorney. Yeah. So I don't know what the hell is going on in Maryland. But it's like the Wild West. Like, all of a sudden, all of Maryland started calling us, being like, these attorneys are all shit. They're not taking any cases. They're only so like over and over and over again, people have been calling us out of Maryland. And for years, I've been like, listen, Maryland's got a lot of options. You're DC adjacent. Like, excuse me. You got good options there. Someone who worked for the firm moved to Maryland and had difficulties as well there. And I don't know what's going on in Maryland. But so like, I am at this point saying, I've heard so many bad things about Maryland. It might make sense for you to talk to like the 4 or 5 national firms that exist. Nadine asks us, when should I expect to speak to my attorney about how much my case is realistically worth, how much we will be asking for as a settlement? So generally, I want a demand conversation to be made. I want to demand so the demand letter doesn't specify a number, but I want to have a real damages calculation, a real all hands on deck conversation about what the demand should be, which is not the same as damage calculation. Those are 2 different numbers. But in the first month, maybe 6 weeks. Zinro says, if a manager wants to claim they were never told about a disability when they were, is it helpful to have text from former managers confirming that you had told them to prove a pattern of disclosure? Yes. BMM says, you are the best, Vincent. I've learned a lot from your videos. I really hope I'm being helpful. Emily Bailey says, is there a reason attorneys wouldn't be interested in taking a case that is pretty straightforward case of disability discrimination? Person was liked by all, very experienced in the field, and had no disciplinary contact. They requested reasonable accommodations after receiving attendance points when he had to leave work 30 minutes early after his insulin pump had issues and blood sugar was over 400. Accommodations were essentially denied, and he was then terminated on his 90th day and told they didn't have to give him a reason for termination because it was in the 90-day probationary period. So, Emily, I don't know what's happening in the presentation. As you are presenting those facts, I sit here and say, sounds like a claim. Money, 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 money. I like money. Let's take that claim. So I don't know what's going on that attorneys don't want that. seems like you're describing somebody else presenting this case. And oh, okay. Emily posted one more thing. Key fact. This occurred in Las Vegas at a strip casino. So here's the deal. Casinos in Las Vegas, it is very hard to sue them with local counsel for a variety of reasons. And local employment attorneys in Vegas, in my experience, try very, very hard to keep national firms out, going so far as to call and threaten national firms that they will do horrible things, and ignoring like Supreme Court law saying that, like, so the Supreme Court's been very clear, like we can represent someone in the EOC in all 50 states. Not all states agree fully, which is silly because the Supreme Court is the highest law in the land and the last word on this. But you'll get local attorneys who call up the national firms. Like this happened to me. I mean, not so long ago. And like 6 attorneys from one state got together, like, we're the 6 families of employment law in this state. And we're going to get you if you do this. This is illegal. You can't come in here representing employment cases. And we also think you engaged in advertising breaches, illegal advertising. And literally all 6 of them were on the phone with me. And I was like, well, I don't advertise. Like literally in that market, we had no ads. So I was like, yeah, I don't advertise. So the things you're saying we said in advertisements are lies because there are no advertisements. And you can make whatever threats you want, but the Supreme Court appears to have my back. So no. And they try to keep people out. And that's to some extent true in Vegas, and all the local attorneys who might be complicit in trying to keep national firms out, unsuccessfully, I might add, but they're trying to keep national attorneys out. They're trying to stay on the good side of the casinos. The casinos kind of run that town, from my understanding. So like, oh my God, Corey, why are you giving me $20? Don't give me 20. Can I? That's very kind, Corey, but thank you. I'm going to answer your question anyway. I would have. Thank you very much. It's very gracious of you. All right, Emily, I think you're dealing with a local issue. The national firms will snap that case up as long as it's presented well. John Doe, that is not the biggest ever. You're close, but it's not quite. My cat received a bigger, my dearly departed cat received a huge one-time donation. Okay. I'm flustered by Corey's very gracious $20 donation. Let me answer this question. One employee stated, you may buy your shirt online. The manager yelled out, "Scammer." Second time this has happened. I notified manager, but I want to escalate to a higher power. What's my steps? I travel for my job with matching attire. Did you think there was any kind of discrimination going on? I don't think there's anything wrong with you buying. First off, if they're making you pay for required workwear, that's already not going to fly. If there's uniforms, like, you shouldn't have to pay for them. They should be purchasing your uniforms for you. Certainly. So Corey Brady, can you give me a little bit more? I want to answer your question completely, because I want to respect your $20 donation, although I would have answered it fully either way. I thank you so much, but no more money, please. So I'm going to go to some other questions. Corey, please give me more to answer for you, and I will do a full answer. John Doe KCK says, what are some of the reasons a law firm would tell a client they don't need to continue paying while keeping their case? Does it generally indicate a good relationship and a somewhat strong case? John Doe, yes, both. I think I would like to think that reflects that your attorney cares about you as a human being and that you have a case that is valuable. It's either one or the other or both. BMM says, I'm a federal employee and I have a retaliation complaint for 6 non-selections at the EEOC pending hearing. I have 2 additional recent non-selections. Should I file a new complaint or amend my current one? If you can amend, I would say, so you don't have to go through it twice. John Doe KCK says, very first college law courses I took were taught by a Nevada judge. Ironically, I actually have had nothing but good experiences with the Nevada judiciary. In all honesty, that my complaints with Nevada are nothing to do with the judges or the system. Frankly, it's a couple of attorneys who were silly little men. I'm glad Be More Shelley won, that I was able to help. I'm glad you caught the live. Be More Shelley won. Ashton the cat experienced liver failure, very sadly. No problem, Corey. Can you give me more? Give me more. I want to answer the full question for you. I want to go into this fully for you. I definitely want to answer your question no matter what. We got 15 minutes left, and as far as I'm concerned, it's the Corey Brady Show. Scott Niebarger says, speaking of the scammers, were we speaking of scammers? The Beekeeper was a great movie. I will watch that. I will probably maybe watch that tonight. Yeah, Corey, you're the last question. I want to give you a full rundown. We'll do a full discussion of your issue. I'll give you a minute. I'm going to check my emails. Okay. Corey, you working on it? I'll give you a little more time. So there's this weird affiliate program through YouTube where they try to get you to tag like clothing you're wearing in videos. And it's super odd because like the percentages are really high. Like if somebody goes and buys like a piece from Adidas that I tagged myself wearing in a video, I get 20% of the sale, which seems absolutely insane. And I just don't really understand how they can afford that. It's very strange. How we doing, Corey? Oh, here we go. Corey Brady says, I travel for my job for 7 years now, so I see different job sites and people. Job gives a uniform that looks like the store employees. I came out to service a ticket. Alfalfa, go right ahead. So Corey goes on. The employee stated, I bought my uniform from eBay, and the manager called me a scammer. That's rude. That's definitely rude, Corey. I'm with you there. I mean, you're just trying to blend in as per your job site's requirements. You're not a scammer. You're just making your best efforts to blend in as required by your job. Emily Bailey says, this happened to my 24-year-old son, trying to help him sort things out, but I'm in Washington State and he's in Vegas. Should he look outside of Nevada for representation? He has not yet filed with the EOC. So if he has exhausted his local options in Nevada, then yes, I think it's time to speak with the national firms. That case sounds good and viable and valuable. If the local firms in Nevada will not help him, then I would recommend speaking with the national firms. Anything else, Corey? Alfalfa, do we have your question? Let's go up to the line. I'm done at 6 p.m. Okay. So Alfalfa, I'll read your question. Oh, all right. We're going to go back to Alfalfa's question. We got a question from Corey Brady. Corey Brady says, this hurts my character. So they called him a scammer because he picked up a uniform off eBay for the job site because his job wanted him to blend in. And he says, this hurts my character, for I feel the employees hurt my character and how I represent myself on the job. Want to know the proper steps to file a suit against this. I'm going to be honest with you. I don't know that necessarily gives rise to a claim that I would recommend bringing, right? Some jerk calling you a scammer, that person's a jerk and they're wrong and they're rude, but it might not be a viable source of a claim for litigation, or if it is a viable source of claim, and check with local counsel, because every jurisdiction is different. A local attorney might feel very differently. Maybe there's some special law about saying rude things about people in the workplace where you are. Like, it's entirely possible, right? So check with local counsel. But in most jurisdictions, in my experience, that would probably not be enough to give rise to a valuable claim, or at least a claim that was valuable enough to be worth pursuing. Or maybe even in some jurisdictions, it would not even be a viable claim, let alone valuable enough. I hate to be negative. That's not something I want to be here, but I do want to be honest with you. I hate to frustrate you. If there's a way that I can, I don't know. I don't know if I can do that. I'm sorry. I hate giving you that answer because that person was a jerk and really scummy. And I'm sorry that you experienced that in the workplace, but I'm not sure, in my personal opinion. I'm just one attorney. Okay, good. Good. I'm glad it helps as you type it out. Makes me happy. All right, let's turn to Alfalfa here. Okay, sorry, Vince. I know you've talked about this before, but I'm still confused. How workers' comp and civil complaints against the employer related and relevant to each other. I get they are in separate courts, but wouldn't one finding impact the other? Okay, so workers' comp court, generally speaking, is trying to determine if an employee was injured in the workplace and how injured they are. That does create evidence, incidentally, that can inform a workplace discrimination case, workplace sexual harassment case. There's a lot of things that can go on, right? But a workplace discrimination or workplace sexual harassment case is trying to determine if workplace discrimination occurred, or if workplace sexual harassment occurred, or if workplace retaliation occurred, right? So you can see they're trying to prove two different things. They're in two different venues with different rules of evidence, generally speaking, and both cases can create evidence to be relevant to the other, right? So if you, in your workers' comp case, establish really good evidence that your employer was aware of your injuries and your disability, that is absolutely relevant to your failure to accommodate case, as an example, right? I think we got some bots in the channel. Definitely some bots in the channel. The checkmark bots. But it wouldn't necessarily, what they're finding in that action is not the same thing that they're going to be finding in the other case, right? The two cases are trying to determine answers to different questions, if that makes sense, Alfalfa. Go right ahead, Ali Shan. What's the question? I don't know what's going on here. This is very suspicious. Be More Shelley 1 says, employer called the person dumb and stupid and went on a false write-up. Person went on leave, FMLA denied a week after fired. So that sounds like an FMLA claim, if nothing else. Maybe a discrimination claim in there. Certainly there could be something there. Emily Bailey says, is it better to file the EEOC complaint sooner with or without representation, since that has to be filed regardless before you can sue? Emily, my preference, if I'm taking a case, is that we file the EEOC case for the person, but we certainly do take cases after the EEOC case has already been filed. Interesting. Ollie Sean appears to have asked the same question Emily Bailey just asked. Well, the answer stands for both of you. Anyways, everybody, I'm going to shut this down because I don't really know what's going on. We got some checkmark people in here doing stuff. Oh, May HM says, if a lawyer is registered with the Supreme Court, is that a really good indicator of their capabilities? Not necessarily. Not necessarily. All right, everybody. Be well. I hope we were helpful today. Take care.